Now, less than a fortnight after the gang rape and murder of a veterinary doctor in Hyderabad, the Andhra Pradesh cabinet has approved a bill which proposes death penalty in cases of sexual abuse of women. It also seeks completion of the entire trial along with judgment within 21 days of filing of the FIR. At present, there is no provision for death penalty in Indian laws for rape convicts. However, Criminal Law Amendment Act 2018 and amendments to the POCSO Act provides for death penalty as a possible punishment for aggravated sexual assault on children below the age of 18 years. Now, the real issue here is time taken in the final disposal of cases of rape and sexual assault. So what are the hurdles in delivery of speedy justice to the victims, and how can these hurdles be removed? For more on this, we're joined by a distinguished panel of guests. Let me first introduce them to you, beginning with Ms. Sunita Ahuja, Advocate, Supreme Court. We also have with us Mr. Satya Prakash, the legal editor of the Tribune, and we're also joined by Justice S.N. Dhingra, former judge of the Delhi High Court. Welcome all of you to Rajya Sabha TV studios. Let me first begin with you, Satya, and let's look at the, tipping point here. That's the decision taken by the Andhra Pradesh cabinet to enact such a law. One more stringent law added to the list.
Well, it's a knee-jerk reaction. We all remember what happened in 2012, December 16 gang rape case, and thereafter in 2013 there was amendment in criminal law, and rape laws have been made much more stringent. In 2012, we had POCSO that was made much more stringent. So it's this entire question of dealing with the issue of rapes and punishing the guilty with much more stringent laws. I don't think it's going to work. Why? Because it's not per se about law, not that we didn't have laws. We did have laws. The problem is about implementation and timely delivery of justice. So how you can ensure timely delivery of justice? Primarily, there is a complete mismatch between the number of crimes which the court system is asked to handle and the human resource that they have in terms of judges, in terms of paralegal staff, and also the infrastructure. Unless that part is handled properly and the problem is addressed on the front of human resource, I am talking about the number of judges. I don't think, even if you put that 21 days deadline, it's not going to happen. One. Second is, I find it unrealistic. In 21 days, you complete everything. It's unrealistic because you presume that the system will be functioning with utmost efficiency, which is not the case in most of the states. So the system should be reasonable, and then you take into account the way it actually functions. Not that it's a sort of utopian idea that everything will be done in such a manner that outcome is there within 21 days. Because you have investigation, you have sometimes even forensic reports, they don't come in time. So, and there is much of the delay is because of the delay in getting the forensic report. And in such cases, I'm talking about rape cases, forensic reports are very important. So, I don't think it's a very, I would say, sane idea, because unnecessarily you are enacting laws which cannot be implemented. So, you should be slightly reasonable while enacting laws. You should take into account the ground situation, the kind of prosecutors you have, the kind of the police investigators you have, and the kind of court system which will deliver the verdict.
The entire justice delivery system.
Yes. So, to me, we have enacted a law, or the Andhra Pradesh cabinet has approved a law which is not has not taken into account the ground situation.
Okay. Ms. Ahuja, if you look at this particular law specifically and start from there, the intent seems to be very noble out here, to try and go ahead and ensure that justice is delivered to the victims in a speedy manner as soon as it can be. But as Satya is pointing out, the way our justice system is, and in fact there are several studies. One of them is from a committee which was set up by the Delhi High Court only after the 2012 Nirbhaya case, and it clearly points out that even the deposition of the rape victim does not take place within the 60 days, which is the stipulated time.
When we talk about, Mr. Dahiya, when we're talking about delay, we are looking at delays at multiple levels. One, delay at investigation, delay in trial, delay at the time of disposal of appeals. Now, to say that having a law for a time-bound investigation, then time-bound trial and time-bound disposal is basically, you see, there are, as Mr. Satya pointed out, we already have laws. In POCSO there are time limits, in CRPC there are time limits. The issue is, why are those time limits not being adhered to?
Yes.
So if we have too many laws, and which can be easily sidestepped, saying that there are not enough people to man the courts, there are not enough resources. So therefore, we are ultimately reducing the authority of law. So we are getting comfortable with the fact that you have a law which need not be implemented. So in my opinion, having a as a knee-jerk reaction, what Sir pointed out, and enacting a law with a full knowledge that the law is not going to be implemented, ultimately is not going to serve the purpose, or even the noble purpose, noble intent which you pointed out. So therefore, a multiplicity of law is actually adding to the reducing the validity of law, authority of law. Secondly, we are not looking at creating the infrastructure. The difficulties, as far every outgoing Chief Justice of India has pointed out in their speech, the problem is about how the court, the vacancy at the lower court levels. That is a larger issue. The infrastructure is a larger issue. That without having the investment in the infrastructure, without investing in the people who are manning those, the courts which are going to conduct these day-to-day trials, how do we implement it? You know, a simple thing, for example, a judge is on leave today. In the case which is listed in a criminal court, will get adjourned, and I'm on a conservative side, by 4 months. And on a non-conservative, on a real practical side, it gets adjourned by almost a year. Even from August 2019, the dates were given for next year, July 2020. So one day, if the court is on leave, just imagine for that one court, the matter has been delayed for 1 year, right? So those are the practical difficulties as far as the trial is concerned. Now you are saying the 21 days. 21 days is not really, it's not just unrealistic, it is a mockery of the criminal trial itself. Because, you know, when the criminal trial starts, once the investigation is over, IO submits all the documents, when the criminal trial starts, there are so many stages when you are confronting people with documents. You are examining them with the help of the memory. So there is a huge amount of jurisprudence behind all that happens. How do you do this in 21 days? You see, it is the purpose of criminal justice system is not to catch hold of people and hang them or to punish them, but to do justice. And when we talk about justice, you know, as a lawyer, we appear both for the accused as well as complainants. So justice is not just in terms of giving immediate verdict, but giving just verdicts. So therefore, in a case where there are, for example, in a gang rape case, for example, there are multiple witnesses, how do you examine them? And how can you examine, a lawyer is expected to examine one witness, or a judge is expected to pay that sort of an attention, more than 2 witnesses in one day, you tell me. It is impossible. You know, we do it, you know, because once you say that it has to be in a little, but ultimately, who will be the sufferer? The justice will be the sufferer.
Okay, the 21 days might seem like, very less time, as you're pointing out, of the entire process as well. But one argument which is given is that why can't the process be prioritized if it's weighing so heavily on the conscience of the entire nation? And if these kind of cases, why can't they be put on priority? And yes, there are fast track courts which the government has said it needs to be set up. Some of them have been set up, and the some of the cases have been tried there as well, and the verdict given there.
See, now that is about the trial. You're saying that yes, in 20 or whatever, 6 months or 8 months period, if an effective investigation, that itself sometimes may take about, 3 to 4 months. It is not that, everything can be done. For example, what Sir pointed out, FSL report. Nowadays, the mobiles, the data, cyber data, digital data has become such important evidence. Now, all that has to be matched. Just you're putting your 65B evidence. So, and these all takes time. For example, if you see, if the mobile has to go, if somebody has made taken a clip or made a video out of it, so that has to be examined. These are complicated processes. It cannot be just done in 2 months, 3 months, 6 months. Why?
Okay.
What I'm saying is the idea has to be, we have to create infrastructure. We have to create infrastructure and things will fasten. And one, of course, the sensitivity and commitment.
Okay.
That is something which is lacking. So we not, instead of just looking at the law,
Okay.
can we look at those also?
Okay. Let me bring in Justice S.N. Dhingra here. Justice Dhingra, one simple question that I have for you is, what are the hurdles, according to you, in terms of ensuring speedy delivery of justice to the victims of rape and aggravated sexual assault, and how can we go ahead and remove those hurdles? There are quite a number of them pointed out by Satya and Ms. Oja out here, but from your perspective.
See, the biggest hurdle which I find is intention. See, the state legislature here has intention to throw dust into the eyes of the people by saying that we have enacted a law that within 21 days the trial will be over. I do not know whether they have made a provision that if within 21 days trial is not completed, who will be hanged, whether the judge, the IO, or who will be hanged. Then you complete the trial. Is that, you see, the process, criminal process is over. After trial, the matter goes to High Court. What time limit has been fixed by this legislation for the High Court? Has they fixed that High Court will decide the case within 1 month? And if the High Court fails to decide within 1 month, the judge will be hanged? Or what time limit has been fixed for Supreme Court? That if the appeal is taken to Supreme Court, how much time Supreme Court will take, and if it is not done, what will happen to the judge? You see, these are just gimmicks being played by the legislature to divert attention that look how sincere we are. For last 70 years, since we have gained independence, criminal justice system is suffering from inertia. We have not been able to bring a single meaningful change by which justice can be given, delivered in a proper, orderly manner even. You see, where the parliament or the legislature pass law, then they forget what happened to the law. How the law was twisted, diverted, misinterpreted by the courts, and then they forget, they even don't bother what happened to the law which they have passed, why wrong interpretations have been given, how it should be set right. See, the few days back, I heard Chief Justice saying that our judicial system is very good. It doesn't need much of the change. If the judicial system is very good, a trial takes place in 30 to 50 years in normal course. People remain in jail for 12 years and then they are declared that you have done no crime. This is the judicial system which we have.
Okay.
You have pinpointed rape cases. Today, press is drumming one rape case or the second rape case. Tomorrow there may be a maverick who may kill school children. Go to a school and kill school children, as it happens in America. And then we'll say, oh, murder is also equally grievous offense. It is very heinous offense. We should make a law, similar law of quick trial about murder. Then you will find ransom cases where children are taken on ransom, and you see there are people who will say, unless you give so much ransom money.
So Justice Dhingra, what you're pointing out here is the lack of infrastructure. Is that what you're saying?
Then what I am pointing out, that you cannot make a separate law offense-wise. You must reform the whole judicial system, that the judicial system should respond to each and every offense in a quick, in a reasonable time. It should respond and the result should be there.
Okay, but one more
And
question.
the duty
One more
lies
question, Justice Dhingra,
not
here is
only on
you're pointing towards the
state
legislative in
legislature.
terms of the kind of laws they make and all that. But if you look at the entire justice system, the responsibility is a shared one out here between the legislature and the judiciary. So it has to be, the effort has to be made from both sides, hasn't it to be?
This is what I'm saying. This is what I'm saying. You see, this is what I'm saying. The lack of intention, in not only on the part of judiciary, legislature, but on the part of prosecution, on the part of judiciary. Have you seen a special criminal bench working round the clock in Supreme Court or in High Court? You see, they keep hearing Ayodhya case for 1 month. Ask them to continuously hear appeals, rape appeals for 1 month, then they will be able to dispose of 20 rape appeals, 20 or 30. See, but rape is not a priority. Why they have not fixed that rape cases or criminal cases will be a priority? You have special commercial bench in High Court. You don't have a special criminal bench in High Court.
Okay.
See, the intention is just to, see, whenever there is something happens, issue a statement that, this is something very wrong.
Okay, Justice Dhingra, I get your sentiments here and I get your point here. Let me bring Satya here. I'll come back to you, Justice Dhingra. Satya, looks like, the entire situation boils down to that basic question which you started with and which Ms. Oja also pointed out. Does everything else, settles down to the question of having proper infrastructure in place to ensure that both the investigation, the trial and the entire process is done in the due course of time as is mandated by the laws which are enacted by the legislature?
No, apart from the human resource, the number of judges and the paralegal staff plus resources, what Justice Dhingra has pointed out, intention on the part of the legislature, executive and also on the part of the judiciary, because as Justice Dhingra has pointed out, you don't find special criminal benches in Supreme Court or High Court, and that is why many criminal cases, in fact in many cases, murder cases particularly, it takes almost a decade for an appeal to be taken up in the High Court. Justice Dhingra might correct me if I am wrong, but why? Because of the priorities they fix. You have special benches, commercial benches, but not special criminal benches. But having said that, there are cases in which trials have been completed within a week or 10 days and 15 days. Those are exceptional cases. That cannot be the rule. Exceptional cases, I am saying there could be a case where you have all the evidence which is available. You have eyewitnesses, maybe you have forensic evidence which is collected, and then you get very quickly the FSL report and all. So this can happen in some cases, exceptional cases, where the system is working perfectly well, but it cannot be the rule. So the legislature, while enacting laws, or the executive, while proposing the law, they should take into account the realistic situation on the ground.
Okay.
They should not, because there seems to be an attempt, because there is an incident in Hyderabad, which was earlier part of the undivided Andhra Pradesh. So fearing that there could be some backlash or people might react angrily to such situations in case similar case happens in Andhra Pradesh, the political class, the government has taken this step. But the proper solution would be the legislature, the executive, the judiciary, they all should sit together, because police investigation is with the executive, lawmaking is with the legislature. The trial system is with the judiciary. All should sit together and try to find out what could be a reasonable time frame for investigation, for prosecution and for trial, and accordingly it can be worked out. But without taking into account the ground situation, if you try to enact a law in which you fix arbitrarily a time frame, I am afraid it can never be adhered to.
Okay, so all stakeholders will have to come to the same common ground here. Let me go back to Justice Dhingra before I come to you, Ms. Oja. Justice Dhingra, how do we look at the solutions, or how do we look at the ways to go ahead and remove these roadblocks which you were talking about in the last 5 minutes or so?
See, the first thing is we must create specialization in the courts. Specialized criminal courts where judges are given training of criminal trials, proper criminal trials. Many judges at High Court and Supreme Court level even do not know criminal justice, what is criminal law. They start giving judgments, hearing argument on one side or their side and start dictating judgment without going into fact. I can show you judgment where the judge does not know the difference between a material witness and a formal witness. He does not know the difference between 162 CRPC and 164 CRPC. I'm talking of Supreme Court. I'm not talking of trial courts. So, unless you have specialized benches right from the bottom till top, where the judges are trained in criminal law, no criminal justice system can succeed. Here, anybody would come and start argue on one point for 1 month.
Okay.
As if the judge does not know law. It is most unfortunate situation in our country that every citizen is supposed to know law, and ignorance of law is no excuse. But every judge is supposed to be ignorant of law, and he is required to be taught for 1 month on one point of law by a battery of advocates.
Okay.
He cannot fix 15 minutes time that, you see, this is the law, this is your point, please tell me in half an hour and an hour what you have to say. He keeps hearing for months together on one point. This is the way our judicial system functions. And the time which is devoted to the rich people and the time which is devoted to the poor people have a ratio. 90% of the poor people rotting in the jail get 10% time of the court. And 90% time of the court is taken away by the rich class of this country. And if these are the priorities, and this is how the judges are concerned, do you think you can ever think of justice being given to the common man and poor people?
Okay.
Because press and media has drummed up one case, you may get result in one case. But there are innumerable cases which have not been drummed up.
Yes, what about the other ones?
And people are lying in jail. Many of them may be innocent, many of them may be criminals. But you please tell them whether they are innocent or criminal, whether they should be in jail or no. Give final result to them. Make time, you make time bound in case of all rich people. People go to the court and get an order. Please complete this trial on day-to-day basis and within so much month. No common man, a poor man can afford to go to High Court and Supreme Court and obtain this kind of orders. So, this system of pick and choose, this system that I know what priorities to be given by the judges must be brought to an end. Then only you can have a criminal justice system where everybody is equal and the judges will pay attention to at least poor men. There should be specialization in all branches, criminal, commercial, constitutional, and there should be permanent benches which should continue hearing these cases so that there is no bench hopping, there is no bench shopping. People don't wait that this bench will go and we will have our decision made from other bench.
Thank you, Justice Dhingra. We're running short of time, but I would like to bring in Ms. Ojha out here. Ms. Ojha, those are quite very interesting and very important points made by Justice Dhingra there in terms of how the judiciary can go ahead and make those changes which are required to be made in terms of specialization, in terms of ensuring that the time allocation or the time dedication to specific cases is done in a specific manner. Bench hopping, bench shopping, as Justice Dhingra was pointing out, is not to be done and allowed.
Now, there are two things. Adding to what Justice Dhingra said, there are two things which I have felt in the course of my practice, which are most vital to be introduced. One is having separating the investigation wing of the police, and then somebody actually takes the onus of the investigation. Of course, the FIR starts, every FIR starts saying IO is responsible, but that responsibility is not fixed. So the investigative agency who takes onus, conducts the investigation, puts all the documents, that is level one. at the level of trial, there has to be more coordination between the public prosecutor, their own witnesses, and as well as the defense counsel. If there are a couple of judges who are actually implementing it in some of the courts, I would not go and name them, but it works very well, because then the judge's diary is known, the PP's diary is known.
Okay.
So that kind of fastens the whole process of the trial. Then another is the summon, the delivery of summon. For example, 5 witnesses have to come and depose. Now, if it could be taken stock of prior to that.
Okay, so there are practical problems, and definitely there are solutions to there as well. Thank you, Ms. Oja out there, Satya, and of course Justice S.N. Dhingra for your views. There it is, clearly pointed out the hurdles in the speedy justice delivery for the victims of rape or sexual assault cases, and the solutions also lie in ensuring that all stakeholders work together to try and come to the common ground, improve the infrastructure, sensitize